Thank you, Madam Chairwoman. Professor Pillard, thank you for being here. Thank you for your testimony. I want to begin by underscoring the point that Senator Lee made a minute ago, that I have real concerns about the nominees this administration is putting forward to the D.C. Circuit. The D.C. Circuit nominations to that court in particular have been politicized for a long time. The Democrats in the Senate repeatedly stopped qualified, excellent nominees to the court, including Peter Keisler, including, I think, most indefensibly Miguel Estrada, where a Democratic staffer put in a memo that the reason to stop Miguel Estrada, one of the top Supreme Court advocates in the country, was, quote, because he is Latino. And for that to be put in writing, to explicitly say we must not have a conservative Hispanic on the court, I think was indefensible. And I have deep concerns about what the administration is doing now with a package of 3 nominees to the D.C. Circuit after the Senate just confirmed a very qualified nominee to the D.C. Circuit. I believe is an attempt by this administration to pack that court, because the D.C. Circuit has been one of the few restraints on government power exercised by the Obama administration. Now, those are all concerns that are extrinsic to you, but they are concerns about the nominations put forward by this administration. But I will confess, Professor Pillard, that I have concerns about your nomination. You've not served on the bench, and so we have a limited universe of materials by which to assess your judicial philosophy and the approach you would take to serving on the bench. The primary source we have are your academic writings. And those writings, to me, suggest that your views may well be considerably out of the mainstream. And so I'd like to ask you about some of those writings. I'd like to first ask about an article you wrote in the Emory Law Journal in 2007, where you argued, and this is a quote, the equal protection critique of abstinence-only curricula in schools is strengthened and rendered more amenable to judicial resolution by the fact that sex education classes are designed not only to expose students to ideas, but also to shape behavior. In that article, if I understand what you're saying correctly, you were arguing that if a state decides to teach abstinence only, that decision by state and local officials, in your judgment, may well be unconstitutional, and it is an appropriate role for a federal court to strike down a state or local government's decision to teach abstinence only. Is that indeed what you were arguing?
No, Senator Cruz. In that article, let me say first, I'm a mother. I have 2 teenage children, 1 boy and 1 girl. And if my children are being taught in sex education, I want both my children to be taught to say no. Not just my daughter, I want my son to be taught that too. The article was very explicit in saying, I don't see any constitutional objection, justiciable or otherwise, to abstinence-only education that does not rely on and promulgate sex role stereotypes. So the concern I had in the article was with inequalities that might be contrary to a long line of established Supreme Court cases on the equality between men and women. That was the only constitutional concern that I identified in the article. In my view, the front line, and in virtually every case, the only people who are involved in developing curriculum are the local schools and the parents in the communities. That is absolutely, I think, under our constitutional system, where the writing of curriculum resides. And when I talked in my article about what would make something more amenable to judicial review, it was because just prior to that, I had said, I don't think there is any settled law making any of this reachable by courts. And as we academics do, I said, the argument that one would make to make it amenable by courts is the one you quoted. So it was in a context of saying this is, there may be no doctrine even raising these, but this is a concern. This is an academic article. Academics are paid to, test the boundaries and look at implications of things. As a judge, I would apply established law of the United States Supreme Court and of the D.C. Circuit and ensure.
Professor Pillard, the arguments you presented here today may well be sound policy arguments why abstinence only should not be the curriculum. And I would fully expect a school board or a state legislature to consider those arguments, and that would seem to me an appropriate forum to make those arguments. What you stated in this law review article was not that as a policy matter, school boards should not choose to do so. Rather, it was that their decision to teach abstinence only may well be unconstitutional, and you explicitly said, and that it's justiciable, that federal courts, the argument for them having the authority to set aside those decisions under the Constitution, you found strengthened and considerable. And I would note that I find that an extraordinary position, and if that is unconstitutional, it is hard to imagine what decisions are beyond the ambit of federal courts. Now, let me get to a second area because my time is rapidly expiring. And a second area of concern I have is the statements you have made concerning in the Hosanna Tabor case. And in particular, there the question was, what is a church's ability to control its own hiring? And in that case, you gave a September 2011 press briefing where you stated that the case against the church there strikes you as a, quote, strong case for the employee. The big news will be if the court decides it for the church. And you stated the position that the church has a First Amendment right to choose who it hires was a, quote, substantial threat to the American rule of law. Now, that position, as you know, was rejected unanimously by the U.S. Supreme Court. And indeed, Justice Elena Kagan, no conservative, described the position you articulated there when it was articulated by the Obama Justice Department as, quote, amazing, to suggest that the First Amendment does not protect a church's ability to make its own hiring. Do you continue to hold those views?
Thank you, Senator Cruz. The court has ruled, and I'm the first to admit, that I called that case wrong. That was a case that commentators acknowledged was a difficult case going into the court because on the one hand, you had employees' ability to access the general rule of law system outside the church, and on the other hand, you had the church's claim to have the ability to have its own internal system. And there were very strong competing interests on both sides, and the hard question was where to draw the line. I was wrong in my prediction about the way that case would come out, and I have no question about my ability to apply that precedent. In fact, I'm grateful for the clarity that it provides in a difficult area, and I could apply that like any other precedent of the United States Supreme Court were I to be confirmed to the D.C. Circuit.
Thank you. My time has expired.
Thank you very much.